So much liability comes with being an employer. Even though your employee is accountable to you for every job and duty performed, the employer is also responsible for his or her employees in so many ways. One of those areas is the health of the employees. This is not only restricted to healthcare providers, but it also extends to the regular workplaces that make health provision schemes for their employees. This is where the HIPAA comes in. HIPAA is the short form for the Health Insurance Portability and Accountability Act. It was enacted in 1996 for the protection of individuals' health information in their movement from one job to another. The HIPAA requires that the U.S. Department of Health and Human Services (HHS), administered through the Office of Civil Rights (OCR), adopt national standards for electronic healthcare information. The HIPAA incorporates 4 basic rules. 1. The Privacy Rule. 2. The Security Rule. 3. The Enforcement Rule. 4. The Breach Notification Rule. These 4 rules are related to strict guidelines for privacy and security controls for protected health information. 5. Protected health information is basically all kinds of health information that an individual has being on a covered entity as it concerns their health status, healthcare provided, as well as payment made for healthcare services that can be traced to the individual. On the other hand, electronic protected health information (EPI) includes any demographic information, medical history, tests, lab results, mental health information, insurance information or other data that identify a client. Difference between security rule and privacy rule. The security rule provides guidelines for ensuring protection as regards confidentiality, integrity, and availability of EPI that has been created, received, maintained, or transmitted. This rule is simply telling you to guide against accidental access of someone to your information and guard against theft of the information no matter what detail or where it is kept. Therefore, you need to create barriers to prevent the risks of accidental access or disclosures. Your employees should also be obliged to do likewise. The privacy rule, on the other hand, refers to an individual's right to exercise control on the use of their information. There is a need to secure your information and prevent anyone from accessing it. While both rules sound quite similar, there are important differences you should take note of. 1. The security rule focuses only on electronic information while the privacy rule includes spoken and written information. 2. The privacy rule is all about non-disclosure while the security rule provides guidelines to ensure compliance. The covered entities. The covered entities are the people that must comply with the HIPAA rules. As provided by the Congress in HIPAA, the privacy rule covers 1. Health plans. 2. Healthcare clearing houses. 3. Healthcare providers that conduct financial and administrative transactions electronically. The electronic transactions here are strictly restricted to those for which the Secretary under HIPAA has adopted standards. They include electronic billing and funds transfer. These covered entities are bound by the privacy rules set out in the HIPAA, including business associates when it comes to performing some of their functions. However, the law does not empower the Department of Health and Human Services to regulate other types of public agencies or private enterprises through the regulation. These entities include employers, life insurance companies, as well as public agencies that deliver social security and welfare benefits. But if you intend to use your software application to enable any of the covered entities as have been listed above, it is a must you are compliant with HIPAA rules. What is a HIPAA violation in the workplace? HIPAA violation is simply the violation against the privacy and security rule provided for in the Act. It is the failure to comply with any standards established by the Act detailed in 45 CFR Parts 160, 162, and 164. It happens when someone who should not have known about something gets to learn about it due to a lack of proper protection against the access of that person to such information. There are hundreds of ways the HIPAA rules can be violated. Here are a few. 1. Impermissible disclosures of protected health information (FI). 2. Improper disposal of FI. 3. Unauthorized access to FI. 4. Failure to conduct a risk analysis. 5. Failure to implement safeguards to ensure confidentiality and integrity. 6. Failure to monitor FI access logs. 7. Theft of patient records. 8. Failure to terminate access rights to FI when no longer in use. 9. Sharing of FI online or through social media platforms without authorization. 10. Failure to document compliance efforts. 11. Mis-mailing FI. 12. Unauthorized release of FI to unauthorized individuals. 13. Failure to encrypt FI or use an equivalent measure to prevent unauthorized access. Here are some guidelines employers can take to safeguard against HIPAA violations. 1. Never call the doctor. There is a tendency to call an employee's health care service provider to make inquiries about some information. Do not fall for the temptation if you do not want to be liable for a violation. 2. Safeguard medical documents. Some employers require medical exams as inclusive of an employee's health care program or a requirement to get offered a job. In situations like this, you must keep medical information totally far away from the regular records of the employee. It can be done manually or electronically. 3. Electronic FI should be protected within the self-insured healthcare insurance. You should be HIPAA compliant if you operate an administrative service-only plan where employees are paid their benefits with the company funds. 4. Protecting group health plan information. If your group health plan requires detailed information, you should ensure to review the documents sent to the HR department. Also, review the information the group health sends to you. 5. Review employee assistance programs. These are platforms where providers have to transmit some information for payment. As an employer, if you want to be HIPAA compliant, you have to shut this down. 6. Non-disclosure. Except your employee has authorized you to do so, do not be so overjoyed to disclose a good medical condition. For example, pregnancy. Do not be too sympathetic to disclose bad or critical medical conditions. 7. Employee monitoring. HIPAA employee monitoring allows employers to have access to insider threat detection through capabilities provided by technological advancements. This can happen through checking the company's communication channel, examining who accessed data, where it was accessed, and what the information accessed was used to for. This way, employers can determine normal and abnormal information. They can also adopt methods such as rule-based risk analysis, IT forensics, and live history playback. 8. Enforcing the minimum necessary rule. The HIPAA minimum necessary rule provides that employee access to FI should be restricted to information necessary to effectively perform their job. This way, employers can limit exposure to FI breaches. How employees can prevent violation of HIPAA laws. These apply mostly to employees like health professionals and healthcare providers in clinics or business entities. 1. Be informed. Employees should not be oblivious of the fact that ignorance of the law is not an excuse. Therefore, they should seek to be up to date with information as regards the services they are providing and laws that back them up. Regular education in the workplace on the HIPAA, what it stands for and protects, as well as the punishments for violating the laws, should be available to the employees. Also, if new rules have been created or new standards have been set, such information ought to be made accessible to employees to ensure that in the dispensation of their duties, they pay attention to the HIPAA laws. 2. Maintain possession of mobile devices. Mobile devices used to store a patient's health information has constituted the most common examples of HIPAA violation, especially when the devices get lost or stolen. Covered entities are obliged to keep their mobile devices from open view and out of the wrong hands. Employees should also bear in mind that the company does not bear the brunt for any form of loss or theft of an employee's mobile device. 3. Encryptions and firewalls. In case your work device gets lost or stolen, this is a backup plan for you. The encryption and firewalls are technologies that allow you to remotely lock or erase all data and information on your device. However, the encryptions and firewalls have to be up to date to enable it to protect a patient's information. 4. Correctly store files. Misfiling a patient's file or saving it in the wrong folder can result in a costly mistake. Employees should endeavor not to be distracted when filing. 5. Properly dispose of files. Employees should not forget to shred paper files before throwing them away. This is why an electronic filing system is preferable. 6. Never disclose passwords or share login credentials. Every employee is given a login through which they have access to sensitive information. These login details should be private and should never be written down. They cannot also use these login details to access electronic file information, or else their jobs may be at risk. 7. Delete all medical records with you when you change your job. Employees in clinics and other healthcare facilities should not take medical records of patients with them when they change jobs, no matter how close or solid their relationship is with the patient. It can result in criminal charges if care is not taken. 8. Do not access your medical records using your login credentials. The privacy rules allow patients to have access to get copies of their health records on request. However, employees have no right to access their medical records with the login credentials. Rather, patients are to submit a request for a copy of their health information through the right channels. 9. Social media. Many healthcare organizations have created standards and rules to cover the use of social media by employees. Normally, contents that would disclose traceable information to a patient should not be found on social media platforms. Interestingly, the rule has extended to pictures and videos. It does not matter whether the picture includes the patient's name or not. Posting a patient's picture on social media violates the standards set in the HIPAA. The place of the Human Resources Department in handling HIPAA violations. If you hire a third-party administrator to manage your company's health insurance program, the Human Resource Department will still have access to FI and electronic FI. More so, if they cooperate with the third-party administrator to coordinate the health care plan, the information contained in the plans may be subject to protection by HIPAA. How HIPAA violations are uncovered. Most times, HIPAA violations are uncovered by the covered entities through internal audits. Here are some ways in which the violations are uncovered. 1. Through employees who self-report HIPAA violations and potential violations by people. 2. The HHS, Office for Civil Rights. They are the main enforcers of the rule and they investigate complaints reported. They also report complaints of HIPAA violations reported by healthcare employees, patients, and health plan members. They also conduct periodic audits of HIPAA-covered entities as well as business associates. 3. State attorneys general have the power to investigate breaches and they conduct investigations based on complaints about potential violation of HIPAA laws. If you are a healthcare employee and you find out that a HIPAA violation has occurred in the workplace, you should report without hesitation to a HIPAA Privacy Officer. The HIPAA Privacy Officer will go on to investigate, which will include a risk assessment. The risk assessment will then determine whether the violation is reportable. This is because not all HIPAA rules violations that are reportable. If a covered entity fails to notify the Office of Civil Rights of a reportable HIPAA violation, it will amount to financial penalties. Most employees might be unwilling to dispense their contact details when reporting violations. Reporters are protected from being punished by their workplace for disclosing violations in the workplace. The OCR only issues financial violations when there is willful violation that undeniably amounts to negligence. Most times, HIPAA violations are settled through voluntary compliance. Punishments of HIPAA violations are mostly for companies. Some of them include: state attorney generals may issue fines up to a maximum of $25,000 per violation category and calendar year. OCR can issue fines of up to $1.5 million per violation category and calendar year. Healthcare providers, health plans and business associates of covered entities can be fined. There are also potential fines for individuals who violate HIPAA rules. Criminal penalties may be awarded. Criminal penalties may be awarded. Did you find this video helpful? Kindly subscribe to our channel below. Then turn on your notifications so that you'll know once we post a new video. Also, drop your comment so we'll know your thought. Don't forget to check the description below for more details. Visit our website, officema.com for more office content like this. Thanks for your time.